What happens to my estate plan if I move out of state? What's up, everybody? My name is Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. So we make these videos to help educate people for free. If you have questions, feel free to submit them, comment, like, share. We'll be happy to try to answer them and post videos so other people can learn as well. So on with the question. What happens to my estate plan if I move out of state? Well, it really depends on what type of estate plan you have. If you are someone who has a will, that can be very complicated because all the states, they're not all in sequence and match the requirements for a valid will. So in some states, you may only need just a notarized signature. In the state of Alabama, we need 2 disinterested witnesses. And disinterested means that they're not going to be inheriting anything or receiving any benefit from that will. So if you have a will and you move, it's a really good idea to have it reviewed or modified to fit those requirements and probably have the governing law changed. Now, if you have a trust, that opens up a completely different ballgame. If you have a revocable trust, trusts across 50 states like that are completely valid. The only thing that you may really want to change in that is just the governing law. So if you are somebody that lived in Florida and you moved up to Alabama, then really that would only be the thing that you would change. Now, where it gets extremely complicated with trusts is if you have an asset protection trust. Typically you see these where people are trying to protect assets for Medicaid eligibility. And in those, that can be a very, very complicated and nuanced answer. That's because in some states you can actually receive income from those trusts, from the assets, and in others you can't. So it's a very difficult situation and complicated deal. And in that, you may want to go ahead and have that completely reviewed or modified to be able to fit for that, I can speak, I promise y'all, that Medicaid eligibility. So in that instance, there would probably have to be some pretty big revisions. So that's really the answer. If you have a will, more than likely you're going to have to make some changes and make sure that it complies with the state law in your new residential state. Trusts, revocable trusts are typically okay, and if you have an asset protection trust, your mileage may vary. So again, my name is Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. We'll see you on the next one. Take care.